Ian, welcome. Really awesome to see you and to meet you and get to talk to you. Could you kind of introduce yourself and what you do?
Well, I work for Snyder Law. I'm a licensed attorney in Pennsylvania and New York, but with intellectual property such as trademarks and copyrights, those are things that are covered all over the United States because it's substantially federal law. So I can do it for someone who's in Washington, who's in Texas, who's in Alabama. There's no real sort of restriction on that. But I also focus on both protecting people's IP, but also helping them register and set them up in the first place, whether incorporating them, discussing how best to market things, also doing marketing and licensing agreements. I've done for a couple of film productions at this point, documentary, one film that's in active production, and a couple of film restorations in the past.
Wow, that's really interesting. So you're an entertainment lawyer as well?
Yes, entertainment and trademark. But like most attorneys, I sort of do a little of everything, but entertainment and copyright and trademark substantially.
Awesome. Well, thank you so much for joining us. So that's great. So what you do covers the whole of the United States. So this isn't state specific. So guys, if anyone needs help or wants to ask someone about this, you can talk to Ian, and I'll post all your contact details in the chat with the replay for this as well. So Ian's from Snyder Law. Cool. So I'm really excited to talk to you, Ian. What we do, we have several groups, and we're all about creating products, creating coloring books. And it was Jordan that put me in touch with you. And Jordan is one of our members in the coloring book mastermind. And he did something really interesting. He made books based off movies that weren't copyright. Is that right? I think that was what happened.
Substantially based on materials that had been, at least that were not currently in copyright anymore in the United States.
Yeah, he did Night of the Living Dead and the Manos movie, and there was another one as well. I know you're in the chat, Jordan, so I was fascinated by that. He got a lot of attention with those books. A lot of people, I know you got a big deal with the MST3K reunion, Jordan, and a lot of really awesome things happened with that. So that was really exciting for us to see. Oh, and the Krampus. So first of all, Ian, can you kind of explain to us about public domain? What is public domain?
Best way to describe public domain are titles that are no longer protected, once again, in the United States by copyright law, either because in certain cases they weren't registered originally, either under the Copyright Act of 1909 and to a certain extent under the Copyright Act of 1976, or they just weren't renewed, and they've fallen into public domain. It's actually pretty hard today for a modern title it's nearly impossible to actually fall in the public domain, but really previously in 1980s, it wasn't that uncommon. A lot of times, Roger Corman's probably well known because he didn't want to pay to register it. So a bunch of movies he would make would just automatically enter the public domain. Night of the Living Dead is actually a good example because I want to say they did attempt to register, but the problem was they put a copyright notice on the film itself, and thus it went into the public domain.
That's really interesting. Is there like a rule of thumb for, like, it's 1923? I know anything before 1923 is public domain. Is that true?
I think it might be a little later, but actually Stanford, if you type in copyright Stanford terms into Google, there's usually a very nice chart that sort of explains it. Best rule, easiest way to say it is anything before 1920 you should be good to go with. There is such a thing as state copyright law in a couple of states and unpublished works, but federal law always overrides any state law, and unpublished works is sort of its own little niche. And if it's unpublished, generally you don't know about it until it's been published. But anything that's been published, for example, should be good. I mean, that's probably why you've seen all like the Pride and Prejudice and Zombies, Abraham Lincoln Vampire Hunter, I don't think was based on anything, but Pride and Prejudice with zombies was essentially taking large chunks of Pride and Prejudice, and I'm sure there's been a couple of other ones. But anything you want in the 19th century is good to go. So if you've been itching to have a zombie version of Francis Parkman's Oregon Trail book Go for
That's
it.
a cool idea. There you go, guys. That's a good idea. And I know there's like Alice in Wonderland and Shakespeare and like
Yeah.
Austen and Bronte books. Yeah, I love public domain. I think it's such an exciting gold mine of things. And you can use anything that's in the public domain. You can do anything with it, can't you? You can
Right.
like publish it. You can put it on perfume, or you can put it on coloring books, or pretty much anything.
Well, interestingly, there might be some exceptions where there's movies that are in public domain or literary works, but there's a character involved that's been trademarked or is copyrighted in other works. So you may be limited to, I guess the best way to describe this now, all the James Bond movies are copyrighted, but just say, for example, that for one reason or another, You Only Live Twice wasn't copyrighted properly. You could use anything physically from that movie on the screen, pictures, sound, but you couldn't necessarily just use James Bond because he was in a public domain film. You couldn't use something, say, from Goldfinger. There's probably good examples with the script, or excuse me, it's either the screenplay or the music for It's a Wonderful Life, which is how, I want to say, Public Pictures or one of the studios was able to gain access to it, because it used to be on all the time. If you notice now, it's only one authorized screening at Christmas each year, as opposed to, on every network and even like any UHF station.
Like Alice in Wonderland be an example. Like I know you can use the original illustrations.
Right.
You can't use what Disney have done to it. Like
Correct. A good example, another one would be Sherlock Holmes. You could use obviously all the artwork that Sidney Paget did for when it was published in the Strand, but you wouldn't be able to necessarily use anything that was in Jeremy Brett's portrayal for Granada Television. Now, interestingly, you could use Nigel Bruce and I'm blanking on the other person who was in it, the ones they did for Universal. And I'm going to kick myself because I know it, and when I go home, I'm going to look at it. But I just remember Nigel Bruce, and I forget the other person, and it's driving me nuts. But that one series is interesting because it did enter the public domain, even though it was made by Universal.
Mm-hmm.
So that's why a good way for most people have actually encountered the public domain a lot, and they've never realized it. If you've ever seen like low-cost Three Stooges compilations, usually it's 4 shorts. And I know this because I actually had this as a kid and I didn't realize it at the time. One is Mouse in the Palace, the other is the courtroom one, Sing a Song of Sixpence. I forgot the fourth one. But they weren't properly copyrighted, so you're free to do whatever you want with them.
Wow, you're throwing out ideas here for everyone. This is great. Thank you, Ian.
Sure.
So I've just got so many questions for you. People have been asking so many questions. Another question that I've been asked a few times, if you hire someone to do artwork for you, because I know copyright kind of works both ways. You want, like, if you put something out there, if you put a coloring book out there, you want to protect that. How do you protect yourself? And especially, how do you protect yourself if you've hired someone to do the artwork for you?
Well, one thing, and this is something we often do, is we draw up what are called work-for-hire agreements. Those agreements are where the artist agrees that none of the work they're doing is all work for hire. They'll receive a certain amount of money for it. They're willing to any claims to copyright or any originality in it, any sort of royalties that aren't specified in the agreement. They are purely being paid for that work, and they have no interest in it. Though there is such a thing as reclaiming an interest. Jack Kirby's heirs, I believe, tried doing that, though they settled before it went to the Supreme Court. There is an example of reclaiming it after a certain amount of period that you could reclaim the rights to a character, except for work for hire, and that's what the crux of that case was. So really the best thing you do is have good agreements in the first place. You'd be surprised. I mean, most people, and I've discovered this a bunch of times, don't want to pay for attorneys at first because, they're just starting out. Truth be told, most of the problems that I later solved for clients, or I've solved for a couple of clients, would have been solved if they had gotten an attorney on, and they probably spent more money because of it. I mean, I guess that is arguably beneficial to me as opposed to the client in the long run. But that's really what you can do. And the other thing is, even works based in the public domain can be copyrighted. You can copyright the new work you're doing on. The underlying work, like say, going back to Alice in Wonderland, say if you did Alice in Wonderland and Giant Robots, you could not copyright any of the text from Alice in Wonderland or the underlying Alice in Wonderland story. You could copyright all the text you've just written about the giant robots, new and unique things related to it, marketing you create for it. So you can copyright things in the public domain in a sense.
I want to write that book right now. That's awesome. Alice in Wonderland and the Giant Robots. That's really cool. Do you automatically have copyright over anything you create? Is that true? Or because I know a lot of people want to do the poor man's copyright, or they wanted to sort of mail it to themselves.
Yeah, that truthfully sort of has no value. It's worthless. The poor man's copyright. Everything, and this is one of the sort of innovations of the Copyright Act of 1976. Anything, once it's put upon a fixed method, sort of such as written down, recorded as an audio, filmed, it's copyrighted. But there's an important distinction. It is copyrighted, so it's not going to enter the public domain, but it's not registered. One difference between an unregistered work and one that's registered is, say someone takes your work. If you want to sue them, first of all, you're going to have to register your work, and you have to pay for it to sort of be expedited, which is substantially more. And if you haven't registered it, you can only get certain types of damages. You can't get attorney's fees or compensatory damages, which truthfully make it pointless often to sue because the costs are just too much, because you're going to be paying the attorney. There's no coming back for it. And the base costs, while they can sometimes cover it, are still not as good as if you can get attorneys and punitive damages. But that is one of the differences, and you will have to register it first. They will absolutely dismiss any suit based on that. And truthfully, if the pirate's smart, or the person taking it, they'll ask for your proof of registration. They'd ask for a proof of registration, because if they know if you don't have it, you're limited. And there are some exceptions. If you discover piracy and you register it for a certain amount of time, you can protect those legal rights. But it's a limited window. It's one of those, if you do it within so many days of discovering it, or this amount of time hasn't passed. But once that's passed, you can register it. You still have to register it to do any sort of legal action, but you won't be able to ever get those potential benefits back.
Oh, so can we sort of like have an example of, like, if I made a T-shirt, for example, and I made a character and I put my character on the T-shirt and I just put that up on Amazon, and then I didn't do anything,
Right.
and another seller put an identical T-shirt. They stole the design and they put their own T-shirt up. What could I do? I would come and see you, or?
Well, first of all, just to say that, once again, that your idea is copyrighted already, but you'd want to have an attorney look into it, because A, to see if you can still register in time, and B, to issue a cease and desist takedown notice. A lot of companies require certain things before you turn it. It's all sort of covered under the Digital Millennium Copyright Act. And I've sent out thousands of those over my career. So it's a fairly common thing to do. And there are also interesting examples. Say if you have your company trademarked on it and the trademark's copied on the knockoff shirt, there's potential Lanham Act violations, which sort of Lanham Act covers sort of the trademark violations and trademark infringement to a substantial degree. But it's something you'd want an attorney for, because there have been so many bad attempts at sending cease and desists. They don't provide the right evidence, or they do it halfway and then they stop and don't finish it up, and the product remains.
Can I just step forward from that? Because that's actually a really interesting point. A lot of sellers that I talk to, a lot of us sell products that people find in stores or they have lying around their house.
Right.
And on Amazon, it's increasingly, we're finding that manufacturers are sending out cease and desist. And there's a lot of conflicting advice. Some people say, ignore it, you have First Sale Doctrine rights. Yeah. Other people say, no, you've got to respond to it and you should act on it. And I know a lot of people worry about, because there's two things going on. There's like the law, and then there's what Amazon will do. Like if someone complains to Amazon. So I often say to people from an Amazon point of view, act on it, because Amazon could remove your listing. But legally, like, what should you do if you receive a cease and desist like that?
Well, first of all, I'd say contact an attorney if you don't already have one, either on a retainer, or what we do is Scribe, which allows you to sort of plan your legal budget for the year, and you can pay it monthly. And sometimes we also have special deals where if you pay it all at once, I'd say I'd only charge for 10 months instead of 12. So you'd be getting essentially 2 months free, but we'd have to look at the product to see what it is. A lot of times First Sale will cover it, but what we need to do first of all is see what it says.
That's really interesting. So, I mean, that's great. That sounds like a really good deal. So you're saying that someone can pretty much keep you on a retainer and then go to you with any problems they have through the year.
Yes.
That's awesome. But that was really interesting. You said a lot of First Sale doesn't cover that. That's interesting because I see people always refer to First Sale Doctrine. Does it only cover certain types of product, or is that?
Actually, yes. First Sale generally does not apply to, or at least in certain districts has been found not to apply to software licenses. So there's a question of if the product was a license. I believe in those cases there's people basically reselling old software that had been purchased under a license. And in theory, you could probably sell the product, but you're not selling the license with it.
That makes sense.
It's sort of the best way to look at it is a bundle of sticks, and that's a good way to look at IP.
Right.
And sometimes the way things are licensed are you only have one stick, not the entire bundle, or you're missing one stick, even if you have the rest of it.
That makes sense. And I know, I mean, what about like a blender or something like that? If I was selling a blender that I bought in Marshall's and the company sent me a cease and desist, I mean, I guess they could go after me because of the warranty.
No, as long as you're not offering it as under warranty. I mean, there are places that don't even care. They'll just cover the warranty anyway. I know, funny enough, Smith & Wesson generally offered a lifetime warranty at one point, and even if somebody had originally purchased it and then sold it to another person, Smith & Wesson would still honor the warranty, as long as it wasn't something done that avoided the warranty. I think there are a couple of other companies. Don't ask me why Smith & Wesson comes to mind, but I just know that's one example.
That's really interesting. Okay, I've got another question talking about buying things in stores. If I wanted to make a gift basket out of, say, I don't know, Hershey's chocolate, if I made,
right.
Or Starbucks, like if I made a gift basket and I put in a bunch of Starbucks coffee and mugs, would that be legally okay for me to sell that online and say I've made a Starbucks gift basket, or is there a trademark issue there?
There's definitely a potential trademark issue. One thing is, it's one thing to include the product if you've bought it, but it depends on the way you advertise it. If you're giving the impression that you have a deal with Starbucks or a licensing agreement, I could see them objecting, because there's a question of, somebody buying Starbucks, sticking into a basket, and say something got damaged in shipping, and even though I can't really think of something with Starbucks that would cause botulism, but say something happened, someone got sick. Starbucks like, look, we didn't sell it with this person, someone else sold it. That's a good example is Disney actually had still does, a very active legal program going after people who have moon bounces with Disney things on them. I think part of the reason was, God forbid somebody gets injured in a moon bounce, everyone, if there's Disney characters on it, even if there's no proof of licensing, you bet you a plaintiff's attorney is going to absolutely attach Disney to that suit. And Disney's got to go through and get themselves removed from it, which can take a long time. There are lots of suits where even on its face, like, why was this party kept in so long? They stay for a while. Sometimes the judge can be sort of cranky about it. Sometimes it can just take a while to get to the motions part of it, and they even have to almost go through discovery. So that's why, just even if you bought it, the way you're associating the product can still be a problem.
Right, so it's kind of about not damaging the brand, or sort of purporting to be the brand or represent the brand. Is that sort of?
To an extent, but also making sure that, say if you mention this contains Starbucks in it, one thing you'd have to do is, Starbucks is a trademark name, so you put Starbucks, the little R in the circle, and put a note saying at the bottom, Starbucks is a registered trademark of da-da-da. Usually that's a good step. You often notice that sometimes, and sometimes you'll even notice things saying this company has nothing to do with it.
Right.
Because keep in mind, the existence of that basket could actually violate an agreement they have with someone else. They could have an exclusive deal with, say, Hallmark to produce Starbucks gift baskets. And they, the people who pay for the rights for that are going to be upset if there's other ones around that may ask Starbucks, if they don't necessarily have the actionable right themselves, to say do something about this. They're making it look like they're authorized, and it's potentially cutting into our product.
So, I mean, I would be able to sell Starbucks coffee on Amazon. I wouldn't be doing anything wrong if I was to sell, because, I mean, the way Amazon's set up is that they have listings, and then all the sellers jump on that listing and sell.
Right.
So it would be okay for me to just maybe jump on a listing and sell the coffee, or to sell maybe a few bags of coffee together. But
well, if you're just reselling bags of coffee that you bought and, retail ones, that's First Sale Doctrine. Now, it's when you're mixed marketing it that's an issue. And it's one of those things that can be case sensitive. But, hypothetically, if you just say had a bag of coffee that said Starbucks that you bought and you're like, I don't want this anymore, I want to resell it, generally you should be fine. Of course, selling food can be its own sort of regulatory nightmare. But, I mean, Pennsylvania, for example, you can't ship beer into or wine. I recall if the state store doesn't have the wine, they will order it from you from out of state. It's really, it's backwards and probably second only to Utah, I'd say. It's gotten better substantially over the few years, but that's an example. Sometimes with state laws, you don't know what could be shipping, could be a problem. An example, I have a friend who he sold a firearm he had, and he just had some accessories left from it. You sell that in the Pennsylvania, the accessories in this case were fine, but you couldn't sell those accessories in the California and a few other states. Now, obviously, that's a fairly unique example, but there are examples of what you can and cannot sell into different states, and that's something you always have to be on the watch out for.
Especially if you're selling online, because you don't know who's
Yeah.
going to order from you. That's really interesting to know.
Yeah.
Oh, I have another question. You mentioned having a trademark in an image, and this is something that's been asked several times in our coloring book group. If you take a picture of a bunch of buildings,
Mm-hmm.
do you need permission to use those buildings? And if there are there trademark or copyright issues with, like, if there was a McDonald's in there or a landmark?
Interestingly, there was actually a case sort of about that. When Sony made their first Spider-Man movie in the late 90s, they actually took Times Square, scrubbed all the existing ads on it, and put their own ads in there that advertisers had paid for. I forget the exact result of it. So there can sometimes be issues, but generally if you're taking a picture in the public, they've put it out there in the public. It's one thing if you're taking it inside, but there can be copyright issues depending on where you're taking the picture. But generally, I mean,
So
it's not too much of an issue.
If I made a coloring book and I did Starbucks around the world, and I just traveled the world taking pictures of Starbucks, could I sell that book?
You might. That would be something that's extremely fact sensitive, and Starbucks themselves would react. Some people wouldn't react at all, but there are other rights holders who absolutely would, because that could be a product they have. They could argue you're using their trademark, the goodwill of that trademark, even if you identify it as someone else or as not being authorized by them. There's been cases that said, well, the book saying that's not authorized is on the back cover, which on Amazon no one's going to really look at. So there's actually some case law about that. So that would be something I'd consider. While interesting, you may have better luck not selling that. But once again, it's fairly fact sensitive.
That's interesting. Do you think there's a lot of it comes down to sort of, can I take on these guys? Like, technically I could do it, but like Disney's lawyers will slaughter me if I do this. Is that a sort
Yes. I'd say yes, absolutely. I think I once said in an article, it doesn't matter if you're right or wrong, it's do you want to litigate?
Right.
And that's true. And I mean, that's unfortunate, but at the same time, there is case law where people can argue, and they do successfully, about fair use. Or that something was in the public domain. There's a very famous case with Nintendo and Universal, where Universal sued Nintendo, and eventually, I believe it was Howard Lincoln was their general counsel at the time, proved that what Universal was claiming, that they were infringing on King Kong had already passed into the public domain years ago due to RKO not re-registering it properly. And basically, if Universal had won that, it probably would have killed off Nintendo, at least in the United States. So sometimes you can fight back, and you should, but most of the times, unless there's an error in it, you're generally not going to have the money to do it. Now, it's one thing if they just tell you to stop doing it, and another if they're saying pay us for doing it. That's different, and that's where lawyers come in terms of negotiating damages or trying to reach a settlement, because truth be told, they don't want to go to trial anyway. They will, obviously. They'll try and get a default judgment, thinking that the person's not going to show up, or they won't be able to afford to, or worse, defend themselves.
I mean, one thing I think is always good is just to talk to people and say, hey, I'd like to make a picture of your sort of premises, your business, and I want to help promote your business, and I think it's really positive. Do you want to work with me? And I think sometimes like that can open doors. I mean, I know that.
It can, yeah. No, I think communications can be it can definitely be a two-way street. It doesn't have to be them coming to you. Now, obviously, the size of the company, their sort of corporate philosophy, and their own internal policy govern it. Once again, I mean, everyone here is making stuff, so they obviously understand wanting to protect or be able to license their own idea out later on. So some will probably be fine with it, and that's actually one of the benefits of getting a material release signed. It's one of those things you sort of have to do. I always recommend doing if you're getting something from another party, or they're letting you sign, and that's one of the things we always produce. I've done a lot of them, and it's just something you should always do just to make sure you're covered so they can't change their mind later on. If you say you do an interview for a documentary, they sign that, they already did it, you're good to go.
Oh, okay.
Once again, it really depends on the company, and sort of that's one of the other things is having an attorney talk to them the first time, saying, how do you guys feel about this? It can prevent a lot of problems before they occur.
Julia's asking a question. She says, do you need to get a photographer's release on a recognizable building if you're going to publish the picture in a work?
I don't think, I once again would, speaking in a hypothetical general sense, I would not think so, because, it's in the public. Now, there are interesting examples of copyrights on certain designs. So there are ways you could actually get designs copyrighted, at least with boat hulls. I know that's weird, but if you ever get bored, look up the Digital Millennium Copyright Act. There's actually a section on hulls of boats. As crazy as that sounds. But truthfully, no. I mean, otherwise you'd have to deal with so many issues with, if you're publishing a news story. Now, granted that there's fair use comes into play with that, but I would say generally no, it's not a concern unless the building, like maybe certain Frank Lloyd Wright buildings might have been copyrighted, the designs on, but
Hollywood sign? Isn't there some issue with the Hollywood sign?
I've never heard of that. Maybe somebody claimed it at one point, but I don't recall offhand about that. Trying to think of one. There does sound like something that has cropped up over time, but I can't give a specific example. Generally, I mean, like if you're taking a skyline photo, it's fine. I mean, if you've gone into like most art places, they probably have at least a couple of the city you're in skyline photos.
That's it. I mean, you can't say, oh, you can't have a skyline photo just because like one little building in there, and they say, no, we don't want any pictures. So, I mean, it's sort of common sense, though.
Yeah, I guess the only questions I could see are, I mean, keep in mind, that's the benefit of doing things in public areas. There's no expectation of privacy, so you don't really have to worry about that. But generally, you should be fine in that because it's in a public area. The only thing I could think of is if there's something copyrighted being displayed. But once again, if it's an advertisement in the public and you're not doing anything that belittles or screws with the advertising, should be fine. But then again, even if you're messing with it, once again, it goes back to fair use. Once again, fair use is an offense and not an automatic exemption.
Can you explain fair use to us? And also you talked about the public eye. What if you use people's pictures? And I know with like all the politics going on at the moment, can I put like Donald Trump on a t-shirt? Is that fair use? How does that work?
God, that really depends because there are certain places that have what's called the right of publicity. California is a pretty notorious example, but there are other states where it's not as big a deal. It depends on like the ability to use someone's image to make money off them. That's sort of that separate area of right of publicity. It really can vary. I think if you've got an argument that you're making fun of something, there's obviously those arguments. But once again, it's not necessarily copyright law, though it is a question of where the picture you're using is from. That can be a huge issue. Even if you're changing it or creating something else, we all remember the Obama picture and all the resulting litigation that came out of that over changing it.
So the photographer has the copyright over. So there's the issue of.
They may that's actually not entirely true. It may be the photographer, but it may be a work for hire. The rights may have been sold to someone else. It may be owned by like Getty or the AP. That's one of the problems that a lot of people presume that the creator retains the rights, and sometimes they do, but not always, and a lot of times.
So if I happen to like see President Obama walking down the street and I took his picture, could I put that picture on a T-shirt?
Yeah, you could. Well, I want to say yes, generally, because you're taking in public. It's a public figure. There's no expectation of privacy. So I'd say you'd have a lot more leeway with that. But once again, it's one of those things you have to always look at in a fact-sensitive sort of manner. Because say you took it in a place that was invitation only, but semi-public, there's a question of whether you're allowed to take those photos in the first place. But like I said, I wish I could. It's always great when you can give definitive answers, and it's unfortunate when I can't. But you always have to double check on those things. And I think that's what a lot of people, and I know I've gone through rights differences with a couple significant amounts of clients, where they just want to almost hit their head into the table where I'm explaining, no, you got to go to this person to license that, and this person to license this. And that's one of the nice things about legal counsel is we take the headache out of you and having to do that. And a lot of times you'll get more, I guess, a better response when you have an attorney contacting, because there's a sort of at least a belief of formal communications or a channel.
Right.
Yeah.
That makes sense. So that's always good advice, is to ask an attorney for anything that you want to do that you're kind of not sure about. It's probably the safest option is to go get legal advice from someone like you, Ian.
Yeah, I would say so, because I mean we can help avoid the problem by finding the party who owns it, and we can work out a license deal. I mean, lots of people like to make money, so if you want to license a product from them, they're usually fine with that. I mean, you're paying for it, obviously, but I mean, that's just how sort of the market works. I mean, so many things get licensed for other things. Like T-shirts, for example. People want to produce a T-shirt for, say, an action movie from the 1980s. Well, who owns the rights to Invasion USA? MGM does. So you go to MGM, you work out a licensing agreement, and then you can put out your Chuck Norris Invasion USA T-shirts. And I've seen that done. You'll see in the bottom corner, same for, I want to think Delta Force too, because it was sort of weird seeing those shirts. But at the bottom, you'd see copyright symbol or license from MGM.
I had talking of fabric and making things. I had one question, which is, could I make something from someone else's work? Now, I know there's like a lady on the internet who makes clothes for
Right.
Disney fabric, and I believe she won some lawsuit against Warner Brothers and Disney and all these people because she was making clothes from their fabric, and they tried to stop her, and she said she had a right to do that. Could you kind of explain? And I thought about necklaces, like if I bought a pendant, could I put that pendant on a chain and then sell that as a necklace?
Well, actually, part of the thing is with fabrics, or some fabrics can actually be copyrighted. You can actually copyright a fabric design. And there have actually been cases where party A is copyrighted this design and party B uses it, or say party B in China via Alibaba is selling it and importing it into the country. I've actually encountered that a few times. So I don't know enough specifics about the Disney one. It's also possible they may have worked out a licensing agreement around the line and just settled.
But I think she didn't copy the fabric. She just used fabric. So she bought Disney fabric and then
right.
So.
Well, it may have been, depending how she eventually advertised it, that, you know, if she bought it and then built something out of it, there's a question of how much Disney can control the use of that object.
Right.
So I'd have to look at the case to give a fairly specific, better sort of analysis. But once again, it changes depending on the use, what the material was, how it's used. You have to be very careful of using other people's designs because it can be really just devastating the way it can come back.
If I went to, say, Michael's and I bought a bunch of beads and then I put them on a string, and could I sell that as Katharine's necklace?
Yeah, that I would think is fine. I mean, unless you can, there's something saying specifically you don't have the right to use this. Actually, a good example is in a video game that just came out, Hearts of Iron 4. There's actually a DLC, which is another band's music. But if you want to stream it, the company actually had to produce something saying it's okay to stream this game because there were some issues with YouTube doing automatic takedowns of it for one reason or another. But they have a note that if you check that DLC, sort of a lightning bolt comes up saying this DLC is not authorized for streaming. If you're streaming it, it is recommended you disable it. So there are some examples, but usually if you're buying beads at wholesale, where it's something that's not claiming, to be copyrighted, trademark, or the resale rights are reserved for something else, you should be absolutely fine.
Oh, that's good to know. That's a really good thing to know.
But I wouldn't put something on it. I mean, like Etsy. Like, it's funny because I bought tons of pirated stuff off Etsy, but don't put, say, Snoopy on a necklace or other things. Like, if it's a plain thing, fine. That's a question of what if it's like a private use. Like, they do make necklaces with cartoon characters on them. Now, the right that they may be granting to you, and they may not say it in the box, but they may argue it, would say, like, this is for your personal use. It's not granted that you can resell these characters in it.
Right, that makes sense. As a sort of like a little detour from that, is it about how recognizable something is? Like, if I went to the dollar store and I bought, say, a Christmas decoration that's just a star, can I take it out of its packaging, repackage it as Katharine's beautiful Christmas decorations, and like rebrand it? Is that an acceptable thing to do?
Well, no. I mean, it's one thing if they don't try and claim copyright, or if it's something that's in the public domain. Say it's like old ads from the 19th century, the early 20th century, excuse me.
If it was just like a generic sort of like gold star that they'd bought from China and that like it is on sale in all the different like Walmart and the dollar store.
Technically, you need the authorization of the people selling it if they copyright it. In practice, probably nothing. Now, I hate saying that because it can give a false sense of security. But there are a lot of times, I mean, we see you can go on all different T-shirt sites where they have things that are clearly using multiple companies' IP. And I had someone ask me once, I see this at, a sale or something, how are they allowed to do it? Maybe they got a license for it. Most of the time, they're fly-by, no one's noticing, and they're just lucky.
Right. So it kind of comes down to how likely they are to sort of litigate against you.
Yeah, it depends on who you sort of piss off, for lack of a better term. Like, as funny as it sounds, I would recommend people never pirate things owned by Toho Film Company, specifically Godzilla. They actually have an attorney, and he's a real nice guy. I've talked to him before handling something, and who's dedicated to that, among other things, but to that task, and has sued numerous things related to Godzilla. It's like, as a company you do not want to mess with.
That's interesting. So don't rip off Godzilla.
Yeah.
Can I make my own sort of monster, my own giant lizard monster, and have the Katzilla or something on a shirt?
Funny enough, there was litigation because Toho tried suing Sears in the 90s over having something called Bagzilla, claiming that it was confusing with their own trademark because they actually have a trademark for Godzilla, not just a copyright. And I believe they said that the suffix alone wasn't enough to claim ownership of an idea. But yeah, you could do that. That's only because I specifically know, as long as you don't make it look like Godzilla, you should be fine.
Oh, okay. So okay, that's good to know. Okay, I had one more question someone asked me to ask you. This was my friend Cynthia asked, if we intend to have multiple products under 3 or 4 brands, do we need to get each brand registered or trademarked? So what she's saying is she wants to make several products, like a soap and a perfume, and she wants to have them all under different brands and put them up on Amazon. Should she get each brand a trademark?
It depends on what you're planning with the products and how much you're doing, because trademarks are a bit more than copyright. But in terms of brand recognition, as long as you're going with a good creative name, absolutely. Because say you want to sell it down the road, you're able to at least take to the buyer saying, here's the intellectual property, we'll transfer you these, it's registered, it's protected. It makes a far better sort of selling package, I'd say. And yeah, I mean, obviously there may be ones that take priority over another in terms of how you budget it. Absolutely, yeah.
So if you're serious about your brand and you want to build it up and do things with it, you can definitely get it trademarked.
Yeah.
But if you're just trying
Absolutely.
something out, then maybe it's not so important. But if like if you were just sort of trying something for a season, but if you were really going, if it was something you
Well, actually, trying for a season might be a good enough reason to do so too, because unless you do something, someone else can do something with it. So anything you're actually sinking money into print labels for, I mean, if you look at the cost of it, you'll make it up in the long run. I would think, as long as the product lasts, and besides, they're business expenses, so obviously I would say talk for your account about, but they're deductible. Legal costs are deductible, so it's a good way to reduce your taxes, because I would assume most people here are single member LLCs, W-9 employees, and they pay their taxes probably like quarterly. And that's something that can be an issue, is how do you reduce some of your tax liability? And once again, check with the account in your state specifically, but legal costs are valid business expenses.
That's a good tip. So
yeah.
I didn't think of that. That's a really good tip. So I think, can we just talk about trademarks?
Yeah, no, that's fine.
What is a trademark, and when would you need it?
Well, a trademark is can actually be a sound, which is kind of interesting, but usually it's a word or or a short phrase or a particular design. So say, I'm trying to think of an example, but say conference room. Now that's probably too generic now, but say you were naming a alcohol after it. Interesting fact is there's numerous different categories for trademarks. There's one specifically I know for literally cigarettes. There's one also just for firearms. So there's different classes you can apply to be in. There's clothing, obviously. I want to say it's class 25 international at least. And what you want to do is a conference room, once again, let's just say it's a liquor, so we don't have to worry about whether it's too generic or not. You could literally have the word conference room just trademarked by itself. You could have a particular design of conference room trademark. Say you want to use a specific script or logo, the way it's written, you can trademark that. And I know sound can also be trademarked, and the NBC Peacock's actually one because it's so strong over time that sound's identified with NBC. But generally, I don't think you'll be doing a trademark for a sound. You have to make sure there's a lot more requirements of a copyright, and this is where having an attorney comes in, because you don't want to submit the application and then come back and hear, oh, well, there's already a trademark for that, or this is too close, or one of the issues, like I said, is if it's considered descriptive, like you couldn't trademark beer for beer.
Right.
It's pretty much anything else, but
Simple,
you can't do certain locations, even if you use a foreign word, what they do is they'll translate it into the most commonly consumer viewed English translation, but most consumers would view that as, even if it's not the exact translation or the only translation, but what consumers would view it as. So just sort of giving it a foreign name isn't actually a way to get around it. But it's fairly complex, but that sort of trademark is your brand. It's meant to protect your brand, not necessarily an individual idea. That's why movie titles aren't trademarked, the exception being movie series. Like Star Wars is trademarked, but Star Wars originally was not trademarked.
So can you use a movie name on a t-shirt? Can you say, I love the Star Wars, whatever?
You'll get sued by Disney. Disney will murder you without remorse. I mean, if you license it from them, you'll be fine, but a lot of times these things truly slip by, like sort of things that are references to jokes. But God, I remember when Force Awakens came out, Macy's specifically had tons of kids' T-shirts, because I remember buying a boatload of them for my daughter. Those were all licensed specific products. Some of them were based on taglines. Some of them were images from the movies. So it's, once again, if you get caught, that's the problem. I mean, or not the problem, but that's how it works. It can be frustrating when you're going through to do it the proper way, and you see someone on one of those one-day-only T-shirt sites who literally is mixed up like Doctor Who, Star Wars, and Star Trek, and you're just like, what? How does that work? And generally, they're lucky, and it's this weird nebulous area that they're not going to be noticed, or they're going to try some lame fair use thing, or like that they're gone in a day or two.
So how can we get hold of you, Ian? But if people want to come to you for advice, where can we find you? I'm going to post your.
I can post my email in the chat. And regarding, there's a question about the payment program and also about trademarks get renewed. Trademarks initially get renewed, and as long as they're in use afterwards, what happens after the first renewals are generally considered incontestable, meaning if there was some guy who out in the Midwest had a Burger King that existed, I believe this actually is the case, that also came out the other time that Burger King did, but they were in different parts of the country, no one can challenge your trademark at that point for any reason. So they can't argue, oh, we were here first. Well, you didn't challenge it the first time. But there is an initial renewal period. I want to say it's either 5 years, it's the first after the first 5 years, and I want to say there aren't any additional ones, but I would double check on that. I'm just going offhand. I know with copyrights, there is a renewal, though it's automatic now at this point.
I think you can check on Trademarkia to find, just do a basic search on trademarks. Is that right, Ian?
I would actually use the USPTO's site, and even if it's more complex, it's the best one to go with because that's what the trademark examiners use in the first place. That's one of the things we do is we provide for our clients, we do the search for them so they don't have to worry about that. And here, let me put the link to my own address and email. And what our payment plan is, it's called Scribe, which actually is something we've trademarked. But what it is, as I said, we give you we can be your general counsel. It depends, the costs sort of vary. It's monthly, but it varies on sort of the size of your business. Obviously, we can scale in terms of what's done. But generally, you can give us, if you have questions, via phone or email, and we'll get back to you, and that's included. It's not like traditional hourly hourly billing that you get with a lot of other attorneys, or that would say if a litigation matter. That would be one that would probably be hourly. But for most things, it means every time I pick up the phone to talk to you, you're not getting charged for it. It's a flat fee. We also do flat fee projects. So if somebody just wants to have something trademarked, we can do that, and you don't have to sign for the Scribe thing. That can be a separate thing. And we also take credit card payments too, which I know for a lot of smaller businesses, we don't charge the extra 3%, is sort of a huge benefit, because sometimes you're using, whether you're getting frequent flyer miles, or just if you want to spread the payment out, or you just don't want to have to put your cash flow at risk. And that's why for us, we can do work with startups.
That's a really cool offering. And I know, Jordan's spoken of you really highly to me. He's like super recommended you. And I know he's had a lot of success with his books as well. There, he's saying it's helped me a ton. We've got one quick question now. Are city or state names trademarked? That's interesting.
It's a weird example. I remember Kentucky doing it at some point. I'd have to actually look into that more. Now, actually, sometimes the logo of a city, it's the way they sort of market it can be. I know that New York's done that to an extent. So it depends how it's being used. I think you have to see what the use is in terms of how it's being done. I know the trademark office is not a fan of trademarking locations. They're not. There are some ways in theory to do it. What they may do, say you want to do like the greatest Pennsylvania something or something. They may give you that phrase, the greatest Pennsylvania something or something, but they'll make you specifically disclaim any trademark rights to the term Pennsylvania by itself.
Oh, how interesting. I've got another question on from that. I know that the government have a thing that any pictures taken by, for example, national parks, those are generally public domain.
I could explain that. Anything created by the federal government, and this is a very important distinction, the federal government is forever in the public domain, whether it's pictures, say stuff taken by the U.S. Office of War Information during the Depression. As long as they took it and it wasn't licensed, say, from a used company, absolutely in the public domain. Maps they've produced, U.S. Army field manuals. People, you often see people throwing those together, like all the crazy ones, in like a pack on eBay, but they're absolutely free to download. Even U.S. produced training films.
That's so cool. So you can republish like U.S. field guides, like military field guides.
Yeah, no, people do. That's actually, there's a very healthy business for that, especially ones that don't get published anymore. Like I know the booby trap one was always famous for getting republished because we sort of talk about how booby traps or explosives can be built. So that was one I remember people in my school sort of liked a lot. But not because they build it, just because it was interesting to know. But there are ones I've seen they can be the most mundane thing, literally for building a latrine. I think there's one.
Oh, what about schools? If I made a T-shirt for my local high school, would that be like a public schools included in that, or is that a different thing?
Well, no. Here's the thing to remember. As I said, federal government, states. There are some cities that do like really cute things, and when I say cute, I mean it not in the actual cute way. Like, and they'll copyright their legal codes or building codes. They publish that, and if anyone else publishes it, they'll sue them. Even though this isn't a governmental one, a good example is the ABA's model rules that they put out. If you publish that and use something that's published that, you're getting sued by them. And I've seen it happen. I know someone is asking if our company does patents. Actually, yes, we do. I don't specifically do them, but Patrick Brady is one of our attorneys that we have our firm. He's formerly with Lockheed Martin. Absolutely does patents and would be happy to talk to anyone here who has questions about patents.
Great. Oh, well, thank you so much, Ian. This has been absolutely awesome talking to you.
Sure. And I also just wanted to say that if anyone who's interested in software stuff, I've done software as a service contracts, but we also have another attorney with us. Everyone just calls him Turk, and that's pretty much, even in formal calls with people, Turk's name is Turk. But he's done a lot of stuff. He's a former software developer himself, ran his own company. So even if it's sort of more of the tech end of it, we can help you with that. And I'll just throw this out there because there are some places that charge for consultations. Ours are 30-minute consultations free. And sometimes if the matter is more complex, we can extend that. The only exception to that are criminal cases, where I know there are some people who charge for those, mostly because the one thing you'll discover as an attorney, and everyone's had this, is the person calling trying to get free advice off of you. And it happens in every profession, but criminal law is a very well-known profession of people trying to get how to solve their legal problems for free.
Well, I got this idea for a Pokemon app that I thought I'd do. Have you been playing the Pokemon game, Ian?
Yeah, I've actually been playing with my daughter a lot. My daughter's 4.5. She absolutely loves it. She loves going after it. And I mean, it's fun. I mean, it's pretty interesting. It actually presents a lot of interesting marketing ideas, especially since they're going to allow people to buy their own Pokestops as businesses. We were actually at a place in Broomall in Pennsylvania called Freddy Burger or Freddy Steak Burgers. I think it's a chain. Somehow they're a Pokestop. And they actually had it on the outside. They had it on the sort of scrolling electronic message board saying, Freddy's is a Pokestop.
Wow.
Yeah, there's been a lot of advertising with that. And there's also a question of how as a business do you advertise in a way that doesn't use the copyright and trademarks of the Pokemon company, which is actually the name of it. And there's a lot of stuff you can possibly do with creating your own apps related to it. You often see people who create unofficial apps. There's a question of how much you can do versus before you get into their intellectual property. Because there's a fairly famous case. There's one of those and this is one of those things that died out with the internet. It was like an unofficial Seinfeld trivia book. And because I had all these quotes from the show, they lost a lawsuit when they got sued by the people who own Seinfeld over it. But you'll see those types of trivia apps that still exist. And it's kind of the Wild West because you will see apps that blatantly try and make it look like something else, or that offer a lot of information. It's really just pulling stuff off an internet website. I've seen that sports websites when you try and find interesting information, say about a football game, and it's just pulling it off a website. So there are potential markets there, especially for app developers, and that's one of our things our firm also does. We do a lot of work with people developing apps.
That's cool. Yeah, I know that's come up a lot in our groups. People have been saying, how can I make money off this Pokemon thing? Like, and what about fan fiction? Is that, like, is fan fiction legal or?
Well, Amazon actually did an interesting thing with fan fiction for, I want to say, one or two brands where they actually, people publishing it, they did a mass licensing agreement with the publisher that they can put it out there and it will be accepted, it can be sold because there's a rights deal cut out. It depends. Most of the time, no, because you're explicitly using a company's IP. Most companies don't care if you're just keeping it for yourself or occasionally publishing it in the sense of a small circle. But if you're selling it, they do. Now, there are some examples of fair use parody. The one example I can think of, I can't really talk about in a group setting, but there are some fair use examples. But generally, fan fiction, at least a non-commercial setting, shouldn't get you into too many issues. Now, for the pure technical aspects, generally it's just illegal.
Right.
It's an infringing use, fair use notwithstanding. If you're doing it commercially, you're definitely going to potentially risk something. Once again, as I always say, fair use is a defense that you can raise at trial or in motions, but it's not something that you can say, okay, stop the lawsuit. We have a fair use exception. And as you can see, people on YouTube often just reprint the fair use section of the copyright code, and it doesn't do anything. Sort of like back in the 1980s, like people would bootleg horror movies or say there was an uncut version of Lucio Fulci's The Beyond that was released on a Japanese Laserdisc. They claim, oh, the Berne Convention says that this wasn't copyrighted, it was all made up and not even remotely true. The Berne Convention, if anything, made more things copyrightable and strengthened copyright laws, and let alone allowing a guy who ran, if you ever Google company video search in Miami, I think it still exists or he sold off some, would just publish tons of bootleg movies from Japan with bad subtitle jobs they did. So they were famous for claiming the Berne Convention somehow allowed them to do that, which was always very funny because there's no way in hell it did.
So it's kind of just it's back to sort of who's likely to litigate and who's got the biggest lawyers is kind of what it comes down to.
Yeah, really it is.
Well, thank you so much for taking the time to talk to us, Ian. I really do appreciate it. I'm going to repost this on YouTube so people will have access to it there. I can't tell you how much I appreciate you taking time out to talk to us. So your information's all there. I'm going to post it again there. It's Snyder Business Law. There's your email address there as well. And thank you so much for talking to us, Ian.
Yeah, no problem. Thank you for having me on.
So I just want to say a big thank you to Ian. Big thank you to all of you for joining us. I really, really appreciate it. I had a few people ask about the Q3 class we did last week. So I just wanted to give a heads up about that. It's still available at q3.blueskyssuite.com. And if you sign up for that, what you get is a replay of the class. You also get all the resources, which is the niches, the keywords, a wholesale list with a bunch of wholesalers, and people are already ordering from some of the wholesalers. And you get the whole replay of the class, which was 2 hours. We talked about making products for back to school. We talked about retail arbitrage. I'm not crying, by the way, I'm just really hot. We shared some of the products that we've sold retail arbitrage. I shared some of my numbers. We talked about Amazon school lists, which guys, this is kind of a secret for you guys, but look up Amazon school lists. It's really, really powerful. You can create lists for any school, which is amazing. You don't actually have to be a teacher to create lists of recommended products. And this is really, really powerful. So if you're interested in back to school, do check out the Q3 classes at blueskyssuite.com. And also we have a Halloween class coming up in August. So if you buy a season pass, you actually get the replay of back to school and you get the upcoming Halloween class, which will be live. And we're going to talk about Halloween candy. I'm going to be sharing what's sold for me in the last couple of years of selling on Amazon, and lots more. So do join us for that. If you're new to all of this, come and join our Facebook group at facebook.com/groups/Katharyne Treasure. Okay, have a great evening, guys. Have a great Friday and a great weekend. Come and join us. If you need an attorney, talk to Ian. He was awesome. He was an amazing guest. We really, really appreciate him. Have a great night, guys. Bye.